All right, so good morning again, ladies and gentlemen, and of course, you have to make sure we remind you. Hey, y'all, please remember to hit the like button. I know y'all come in sometimes and y'all forget, but the main thing, man, y'all gotta hit the like button, man, right. And share the live stream. Come on now, stop playing. Support, support, support. The like button is free, heard? No, I want to give credit to Hot Off the Press because she always does an excellent job and she covers such a variety of topics on our platform. Just her touching on them, for me, somebody that wants to go and look a little deeper, it really really helps. And she show her facts and evidence as well. Um, you know, Sometimes she don't have all the thing in front of her to show you the evidence on one video, and then she'll go and show you on the other video. You know what I mean? The point of the matter is, ladies and gentlemen, that the Joint Select Committee appointed to review the Integrity Commission Act. This was February 18th, 2025. Now, what Hot Out the Press opened my mind to. Sinet Begford, good to see you in the chat. Welcome. Hello. What Hot Out the Press opened my mind to is what I want to open up you guys' mind to. So I want you guys to listen carefully to this exchange. It really takes you to really pay close attention. So put on the listening ears. Take a listen to this.
Trinidad and Tobago, Madam SG.
Okay, thank you. First, although it says prepared by the Attorney General's Chambers, which is true, I have to give credit to Monique Adams, who is not here today. She's unavoidably absent. I'm giving credit to her because we were going through the matrices, minutes, and we realized that the committee asked a whole lot of things of the Attorney General's Chambers. So in fact, there are a number of other matters that time permitting, I will be able to discuss today. But the reason this matrix was compiled was due to questions that had come, I think, from Senator Scott Motley and some others about the comparisons of what's in our Integrity Commission, the confidentiality provision there, and what's elsewhere. Because the Integrity Commission has made a request, I think they have made a request, but there are a number of other persons who have issues with the confidentiality provision, which they call, parts of it they call a gag clause. And so it's for this reason we just did a comparison. Maybe to just give the committee members an idea of what exists elsewhere.
Just a minute, SG. Member Robinson?
I think there are two separate issues. I think the issues in this document relate primarily to the concerns that were raised about the inability of the interpretation of the Act by the Integrity Commission, which they have said precludes them from publishing contracts and other awards by the government. The confidentiality clause, which I think is separate from what is commonly known as the gag clause, which is section 53. But the concerns that I certainly raised were, and I think that was section 56, the interpretation of what confidentiality meant, and the commission interpreted that to mean any information provided to them, which would include information like contracts, which certainly would not have been the intent of the legislation.
Very well. Noted. SG?
Oh, I really didn't have much else to say other than this was just to give the committee members an idea of what exists elsewhere to see if you thought that the provisions in this act needed to be buttressed or remain the same.
Well, since the committee has to make a decision on the matter, it may be helpful to just look comparatively as what is elsewhere. Member Warmington?
If I recall, the Permanent Secretary Board had made a recommendation where this was concerned. And then we have the issue with Turks and Caicos Island and the ruling by the Privy Council, whereby they ruled then that is an invasion of privacy for the Commission to be seeking information that can be had from the declarant. What the Permanent Secretary Board asks for is that they seek such information from the declarant And if there's a case where the declarant refuses or does not supply the full thing, then they can seek an order from the court to go get that information instead of just going directly to a bank or anywhere else for that such information. They ought to seek an order from the court. And that was what the Privy Council ruled in the case in the Turks and Caicos Island. And that's what the issue was. But we hadn't taken a final decision. The Solicitor General gave her opinion, and we hadn't taken a decision. But I think that was what it was, really.
Now, ladies and gentlemen, let me just interject there. Do you guys remember when Delroy Chuck told members of parliament to just tell the commission, tell the Integrity Commission that, you don't have these, they're not willing to disclose these information, their spouses. Now, you see, the issue that I'm having with what Warmington said a while ago, to apply that to Jamaica, there's a few problems. We don't trust the DPP to be non-partisan. We don't trust a lot of people to be non-partisan that's in the court of law. We just don't trust them. The tentacles of corruption in Jamaica appears to be so far and wide that we need, well, I think, for me, I'm speaking for me as a member of the public. How are you doing, Matthew Lewis? For me, I need the Integrity Commission to have certain powers, teeth, so to speak, to act and move swiftly in garnering evidence. Wherever, suspicion, credible suspicion lies, which I trust them to do so on the act that they have, because the detailed reports that the Integrity Commission has given out and the way how they operate has been hailed and lauded by other entities that seek to curb corruption in their own country, right? So the Integrity Commission, for me, is doing a lot right, and I trust them under the stewardship of Mr. Pantan. And because I trust him, he trusts his staff, so I trust them. You understand? So whomever, and you see, the changing of the guard of the Integrity Commission is so important. You guys have to really pay attention to this. This is very important, because what he's suggesting is that, all right, so you go to them, they lie to you and say, oh, they don't want to disclose that information. And so now, to spend more time on the case, the Integrity Commission would have to go see a judge to prove to them that we have credible reason why we need to look into this person's financials. When the purpose of the Integrity Commission is for them to prove that their financials are actually clean. Their statutory declaration is actually clean. So I really have a problem with the idea of them changing that part of the act to amend it as to where they would now have to go to a judge. The Integrity Commission would have to go to another hula hoop just to get the information, when your member of parliament is encouraging the people to literally lie to the Integrity Commission. No. I strongly disagree with that. I don't trust nobody in the JLP personally anymore. And this is one of the reasons. This is another reason why. Let's continue.
Guidance
Patricia,
as to
big up.
whether or not the provisions in the Turks and Caicos legislation was the same as in our legislation, in light of the recommendation from the Permanent Secretary's Board. Because I thought it was important to know whether we could just simply say that this was how we wanted to amend the legislation.
Thank you, Member Scott Motley. We're looking at our section 56, the confidentiality regarding information. Our section 56 has 3 subsections, and it is subject to section 42, subsection 3B, which deals with examination of statutory declarations and publication of summary declarations in certain cases. The memo from the chambers advises that section 47, subsections 1 and 2 of the Turks and Caicos Integrity Commission Ordinance provide 47.1, every member of the commission and every person performing any function in the service or as an employee of the commission shall treat all records and information relating to declarations as secret and confidential, and shall not disclose or communicate the text of any record or information or declaration to any unauthorized person, or to allow any unauthorized person to have access to any records, information, or declarations. Subsection 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of $20,000 or to both, or to a term of imprisonment of 3 years, or to both.
Digicel, live life your way, no free what? Digicel postpaid, sign up.
So it's the same duty to a fine of $20,000 or to both, or to a term of imprisonment of 3 years, or to both. So it's the same duty to treat as secret and confidential all information. Yes. Yeah. Well, no, same in respect of the duty to treat as secret and confidential, not worded in the same way. Yes.
Yes, I think that is distinct from the point that Senator Scott Motley made as it relates to the Privy Council decision and how the Integrity Commission should operate. What we're reading now is basically how the Integrity Commission treats with information. My question is, what particular section of our legislation should we look at to determine whether it is in sync with the ruling of the Privy Council?
Right.
And it's not any of these that we've just read.
So it's actually several issues, and it's different provisions that deal with all of these issues. So this confidentiality more relates to Section 56, and it's more a comparator with Section 56. But the issue, as Member Robinson said, was that in our Section 56, we talk about dealing with as secret and confidential, not just statutory declarations, but government contracts, prescribed licenses, and all other matters. And so when you look at now the comparison with like Turks and Caicos, they confine it to the declaration and matters relating to the declaration. Also, you'll note that they don't have the ongoing obligation for secrecy. So our confidentiality provision, I think, is at a higher standard, which to me, in my view, is consistent with our constitutional right to privacy, which we have. I'm sure most persons understand that the right we have is not really replicated in many other. In fact, I think we can find it maybe in one other constitution, but generally it's a right that we took from human rights declarations. So our confidentiality provision is a little stronger than most others, but then it also goes wider. It goes beyond the declarations. It speaks about government contracts and prescribed licenses. So in Turks and Caicos, you'll see that it is limited to the declarations.
I think the concern, so the provision at 56 does it.
So for the people listening, you notice they're comparing other countries' position and legislation where integrity is concerned and corruption, how the laws and the legislators approach it. So this is why this lady has been invited to clear up that. Big up Valley, they say they want to do every and anything to protect their one another. They know they have illicit gains. This party is a disgrace to Jamaica. Valerie, hey, I can't say I can't say I don't agree with you. Trust me, but that's just my opinion. But we have to expose the action in it. Pay attention and listen to what is being said.
Is it bringing over matters from the contractor general provision and merging it? And the question would arise is whether the public interest is served in concealing information in respect of government contracts, because the contracts are paid for out of public funds. Just let's try to get an understanding of what it is that we're seeking to address. The question is whether it is in the public interest to conceal information in respect of government contracts, having regard to how government contracts are intended to operate.
No, I have a problem with even that being a question. But let's continue.
Right. The other question is whether a distinction ought to be made between statutory declarations, which are submitted by the declarant and which may have certain private and confidential information, as opposed to the government contracts, and also licensees. I think that is what the committee would need to focus its mind on.
Madam Chair, there's a very clear distinction between statutory declarations, where people provide very personal details about their assets and their income. There's also a distinction between in the course of an investigation, where you're going to get information sensitive to the outcome of an investigation. It is clear in my mind that those things must be subject to provisions that protect in the strictest way the privacy and confidentiality. As it relates to government contracts, which go through a very detailed process of public procurement, you have a public procurement authority body, matters go to cabinet. Those contracts, we get them here in Parliament from the cabinet notes. There's no reason for those types of government contracts to be subject to confidentiality provisions. It is clearly in the public interest for the public to know how its money is being spent and where contracts are being awarded. So the amendments must take note of the distinction between contracts and licenses versus declarations or information that's important in the execution of an investigation.
A huge shout out to Mr. Julian Robertson. Let's play that again.
Its mind on.
Madam Chair, there's a very clear distinction between statutory declarations, where people provide very personal details about their assets and their income. There's also a distinction between in the course of an investigation, where you're going to get information sensitive to the outcome of an investigation. It is clear in my mind that those things must be subject to provisions that protect in the strictest way the privacy and confidentiality. As it relates to government contracts, which go through a very detailed process of public procurement, you have a public procurement authority body, matters go to cabinet. Those contracts, we get them here in Parliament from the cabinet notes. There's no reason for those types of government contracts to be subject to confidentiality provisions. It is clearly in the public interest for the public to know how its money is being spent and where contracts are being awarded. So the amendments must take note of the distinction between contracts and licenses versus declarations or information that's important in the execution of an investigation.
You mentioned it was limited to what have you. I'm saying it is limited to that. Where the declaration is concerned, that's one I raise, whereby this Permanent Secretary Board asks that it be amended, whereby the Interior Commission, if you need additional information, is seek it from the declarant. And in a case where there's a refusal or they're not cooperating, then whereby the Interior Commission, if you need additional information, is seek it from the declarant. And in a case where there's a refusal or they're not cooperating, then declarant. It be amended, whereby the Interior Commission, if you need additional information, is seek it from the declarant. And in a case where there's a refusal or they're not cooperating, then they seek an order from the court.
Hey, who mess is this? Oh, man, is this?
Ladies and gentlemen, you notice how this man said that with a straight face and half a falling lips, just not to hide the disgrace upon him face. The man is asking that the declarant, if refusing to give the information that the Integrity Commission want, the Integrity Commission needs to go to the court, you know. Listen to this again, you know. After everything that Mr. Julian does, and I'm going to play what Mr. Julian said again, and listen to his response. Because this is a clear breach for me personally.
It's limited to what have you. I'm saying
Contracts and licenses versus declarations or information that's important in the execution of an investigation.
you mentioned was limited to what have you. I'm saying it isn't limited to that. Where the declaration is concerned, that's one I raised, whereby the Permanent Secretary Board asks that it be amended, whereby the Integrity Commission, if you need additional information, you seek it from the declarant. And in a case where there's a refusal or they're not cooperating, then they seek an order from the court. Instead of going to bank on all of the areas behind the declarant, what they're asking for is that they seek such information from the declarant, and when there's no cooperation, then they get an order from the court, instead of just going directly to the bank or to any place else out there to get this information. Prove to the court that they need that information and the grounds on which they need it.
Prove to the court.
That appears to be.
Prove to the court. And I want you guys to look at her response. Listen to her response after. This man is telling the people, is arguing that the Integrity Commission should prove to the court why they need the information they need. First of all, the Integrity Commission is very clear. We need the assets of your children, your spouse, close family members, father, mother, aunts, you name it. Because it is widely understood where integrity, where your statutory declaration is concerned, the money or the assets can be put in somebody else's name. Example, the recent reports that came out about Darrell Vaz's daughter-in-law being gifted the SSL property. Something that Darrell Vaz himself has confirmed. But we haven't gotten into that yet. We're going into that this morning as well. Wow. So there's clear reasons why the assets of the declarants and the things that the Integrity Commission is asking for should be mandatory. We don't need to go to no courtroom, right, to ask no judge nothing. And I'm very, very against this. But listen to Malahoo Forte. Unbelievable.
Court, then they need that information and the grounds on which they need it.
That appears to be a separate issue. A separate issue. So let's just. I'm sorry. All right. So let's, for good order, let's deal with the issues separately. All right. So
ladies and gentlemen, you see that cheeky laugh? I don't trust none of these people. Him and her.
separate issue. A separate issue. So let's just. I'm sorry. All right. So let's, for good order, let's deal with the issues separately. Let's, for good order, let's deal with the issues separately.
Right there. That's the Joker face right there. I'm on record calling this lady a witch, so I'm beyond. This is my opinion. This lady right here, she and others is working, in my opinion, assiduously to convolute and cloud up things. Want to take out impeachment and all these things from. Listen, hey, let me not start.
All right. So the question we are now addressing is whether the public's interest is served by keeping secret and confidential matters relating to government contracts and licenses issued by the government. And it may be helpful to look at licensing as part of a regulatory regime, that is intended to do, and to look at government contracts in the context in which contracts are awarded.
So,
Member,
right, you're speaking specifically to...
You listen to this.
Is my mic on? You're speaking specifically to section 56.
just a minute.
No.
Can you turn your mic off? Yes.
Sorry, Madam Chairman, you're speaking, you want us to focus on section 56 at this point, is what I'm gathering
Yes.
from your comments.
Yes.
And I would remind the committee that prior to the passage of this Integrity Commission Act, the Contractor General published on a monthly basis, I believe it was, either monthly or quarterly,
Listen to this.
all government contracts that went through the National Contracts Commission, etc. In fact, I believe the only licenses as well, I believe it was only land sales or leases that were excluded from what the Contractor General published. And there was even some question as to why that was excluded and that it should have been included. And I believe even after the Integrity Commission Act came into effect, for some time they were still publishing it. And then after, interpreting this particular section, they ceased. But it makes absolutely no sense, because the process of advertising, tendering, procuring, signing these, approving at cabinet, coming to being interrogated at the Standing Finance Committee of Parliament, etc. These are all already public documents. So it makes no sense for those to be included in this section. I can see the private statutory declarations and perhaps private contracts that may not involve government being included here, but certainly anything to do with government contracts, licenses, leases, etc. I don't see how that can be considered confidential, and it shouldn't be. In fact, it should be. I think they should return to their original practice of publishing these on a regular basis.
Totally agree. Totally agree. Let's play that back. Let's play that back. Ladies and gentlemen, hit the like button for me, please. Thank you kindly.
Right. You're speaking specifically to my mic. Is my mic on? You're speaking specifically to section 56.
Just a minute.
No.
Can you turn your mic off? Yes.
Sorry, Madam Chairman, you're speaking, you want us to focus on section 56 at this point, is what I'm gathering
Yes.
from your comments.
Yes.
And I would remind the committee that prior to the passage of this Integrity Commission Act, the Contractor General published on a monthly basis, I believe it was, either monthly or quarterly, all government contracts that went through the National Contracts Commission, etc. In fact, I believe the only licenses as well, I believe it was only land sales or leases that were excluded from what the Contractor General published. And there was even some question as to why that was excluded and that it should have been included. And I believe even after the Integrity Commission Act came into effect, for some time they were still publishing it. And then after, interpreting this particular section, they ceased. But it makes absolutely no sense, because the process of advertising, tendering, procuring, signing these, approving at cabinet, coming to being interrogated at the Standing Finance Committee of Parliament, etc. These are all already public documents. So it makes no sense for those to be included in this section. I can see the private statutory declarations and perhaps private contracts that may not involve government being included here, but certainly anything to do with government contracts, licenses, leases, etc. I don't see how that can be considered confidential, and it shouldn't be. In fact, it should be. I think they should return to their original practice of publishing these on a regular basis.
So, ladies and gentlemen, he raised a few points there that, I totally agree. These public contracts need to be public. Another lady is going to speak, and I love what she said, so I'm going to play it as well, because she raised an excellent point in terms of certain contracts that need to be private for security reasons, right? And let me let her go ahead. I'm going to come back to Mr. Bond.
Member Charles, you.
Thank you, Chair.
I really don't want to hear this dude. I'm sorry. I can't do it.
Hey,
I
my
can't.
English.
I cannot do it, guys. Yeah, I can't do it. I'm sorry. I'm just keeping it real.
And can I just make a belated apologies for my
This
time?
lady right here.
Um, I have more questions than I really do have a comment, because in as what Member Bunting was referring to, the publication of government contracts and licenses, when it did occur, and the members who would have been participating in the arena at that time can indicate, at what point did the Commission in those days publish list those contracts and so on? At what point in the process? That's not, huh? At the end, once this contract was awarded, right? So I do have some empathy for the Commission in terms of how they have interpreted this provision, because we do use the sweeping language of all information, and that all qualifies everything coming after it. So I think this is one of those that if we're seeking to ensure transparency, then contracts, these kinds of public interest matters probably ought to be disclosed, and we should amend this provision to direct that. I would just say, though, I'll end there. I think I'm in support of it. I of course would expect that it would not necessarily be all government contracts, and I would imagine the ones that have to do with national security, those issues would have the usual protections from that kind of public disclosure. That was the last. Thank you.
So basically what she's saying is that the provision in the Act for the Integrity Commission, it has basic language. It's not very clear. So even though the contracts, the government contracts are public, it's like the Act is kind of restricting the Integrity Commission from, based off the language, from actually, putting out the information at first during an investigation because of the Act itself. They just need to tweak that part. You understand? They just need to tweak that part. But what Warmington wants is for them to not be able to do their job in full. Listen, the JLP has lambasted, blasted, blazed the Integrity Commission for having how much money and not getting these reports out in time. Oh, look how long they've been doing this and they cannot certify the Prime Minister. Right? How you doing, Sassy81? Oh, by the way, ladies and gentlemen, I have relieved every single person. Not one person on my platform has a mod stick anymore. I forgot to say that. I have removed all mod sticks. I learned something, and I have removed all mod sticks. No disrespect. I love all of you, all of my mods. I love you. But what I learned from Armando Black about what is going on YouTube and what is trending, yeah, I have relieved everybody of a mod stick. So you will not see any blue in my chat except for Nightbot. Alright? So I am sorry if anybody feels a certain way. I hope not. And I thank you guys for, supporting in that regard as a moderator when you actually did. But moving forward, yeah, I won't be having any mods. Nah, I won't be having any mods moving forward, alright? But yeah, forgot to say that. Share admission, I said that when you come in, guy. You're the first one that came in the chat. But back to this. I love what this lady said about, she feels bad for the Integrity Commission, right? Because the language is not clear enough. And it's just that part that needs to be cleared up. Outside of that, what Warmington wants to do is to restrict the Integrity Commission from doing their job in a swift and efficient manner by telling them that if somebody lies to them or refuses, don't be like that, Sharon. if somebody lies to them and refuses, right, to give them the information in terms of their financials as a public figure, their wife don't want to give them the information, or their girlfriend, or their sister, or their daughter, or their mother, the Integrity Commission should go to the courts and prove to them why they need to certify their statutory declaration. Make that make sense. I mean, yo.
Hey, who mess is this?
Something is wrong with this dude, man.
Oh, man,
And that's my understanding of what he's coming with. So I want to know from you guys what you understand based off what he has said. I think that's the end of it.
Let's be clear what we are addressing. The
Yes.
concerns have been raised by
Oh, this part is
three
important as well.
entities in
Go ahead.
respect of 56. Firstly, by the Integrity Commission, and it is saying that it's really asking for the section to be amended to achieve a proportionate balance between matters which are deemed secret and confidential and should rightfully be treated as such, and the broader objective of openness and transparency, which are crucial to anti-corruption efforts and are deemed to be international best practices. So that is one ask. Jamaican for Justice has gone a little further and is saying that all statutory declarations should be published. Remember, the section is subject to 46. Well, it says it is recommended, yes, for all parliamentarians. Yes. Just, right? And then the Jamaica Accountability Meter portal, they're asking the committee to consider if Section 56 serves to stem or support the fight against corruption. They're asking that we weigh if the section supports or deny the Commission of its contractual responsibility to educate the public, and they're of the view that the restrictions on disclosure are deleterious to good government, and they are if the section supports or deny the Commission of its contractual
Oh wow, you guys were not hearing me. Sorry about that. I was saying that part, deleterious, right? It means very harmful. So what they're saying is that the part of the act that states that some things is private or whatever. Yeah, they need to take that out. Because it's not helping in terms of transparency and fighting corruption. That's what one of the bodies were saying, but let me play it again.
responsibility to educate the public, and they're of the view that the restrictions on disclosure are deleterious.
Right there. The restrictions on the Integrity Commission is harmful.
Good government.
Harmful to good government and good governance. And I agree with them.
And they are inconsistent with one of the fundamental principles underlying the system of constitutional democracy outlined in Section 2 of the Access to Information Act. Those principles are accountability, transparency, public participation, all of which are significantly impacted by 53(3) and 56(1). And they are recommending rewording of the section to repair the concerns.
Right.
The rationale is that 56(1) is another injurious gag clause that obstructs the Jamaican taxpayer from having access to basic information about how their funds are utilized to contract the services of private sector parties. It also obstructs the very legislators who preside over matters of maladministration in procurement at the Public Accounts Committee and the Public Administration and Appropriations Committee, including, says Jamaica Accountability Meter Portal. Section 56 subsection 1 is another injurious gag clause that obstructs the Jamaican taxpayer from having access to basic information about how their funds are utilized to contract the services of private sector parties. It also obstructs the very legislators who preside over matters of maladministration in procurement at the Public Accounts Committee and the Public Administration and Appropriations Committee, including those who oversee the actual work of the Integrity Commission. Please come on the mic.
Yeah, I think there's some confusion there because Section 56(1) would not apply to legislators, say on the Public Accounts Committee, etc. So it's not relevant to that section. Yes, I think we're all agreed that the publication of government contracts and so on, subject to whatever restrictions for national security and foreign affairs or whatever the standard limitations are. But I don't think there's any disagreement that we could return to the regime that existed under the old Contractor Generals Act, which would, but all public contracts, once they were awarded, not during necessarily the tender or the negotiation process, but once they were awarded, that they should be published promptly. And I believe it was either monthly or quarterly. It slips me now, but it was very regularly, I think quarterly. And I would only say that there was a limitation then for some reason, and I don't know the history, but they did not include land sales by entities like UDC or so on, which I think it should include all of those. So the general.
I think so too. Cause the real estate area is really, you know what I'm saying, convoluted. You need to know about them land contracts, man, and you know what I'm saying, and them sales and stuff, man. Let's get it.
Contracts for procurement, for construction, licensing, etc. I think we're all agreed that those should be published in the interest of transparency in the public interest and so on. So I don't think I don't sense any disagreement in the committee on that. And I don't think it actually operates 56(1) to restrict legislators using other pieces of legislation, whether at the Public Accounts Committee or they examining the Auditor General's reports, etc. So I think they've gone a bit, their interpretation has gone overboard. But I think we can all agree and move on from 56(1) that it needs, we could probably ask help to draft a replacement section for 56(1) that is not as restrictive. And then we could recommend that as in the report of the Joint Select Committee.
No, I don't want this reaction to be too long. So I think I've made my point, and I would love to hear from the people in the comment section about this particular situation where the Integrity Commission Act is concerned and what they're seeking to amend. What say you, ladies and gentlemen? What say you?